you know how to handle a disagreement. You first of all, just leave or walk away or do whatever you're supposed to do. But I'm not gonna come over and get involved in it. I'm not gonna come over and get involved in a disagreement with grown people. Now, if you calling me saying you in fear for your life, which you should have been calling 911.
This case starts simple. A mother says she showed up to help her son. But the details? A physical fight, jumper cables involved, and now a criminal charge. The defense calls it concern. The prosecution calls it serious. But here's the real question. When does helping your child cross the line into assault? Because this judge? She's not buying the excuse. And what comes next completely shuts down that narrative.
This is case number 240-457-4901, the people of the state of Michigan versus Samuel Bryant, M-A-N-I-C. Penniman, defendant is charged with disorderly persons. Today is the date set for sentencing. Appearances, please.
Good morning, Your Honor. Alex Hill on behalf of the people. Also present is our complainant, now victim. Ma'am, will you state your name for the record?
Good morning. My name is Robin Geiger.
Thank you.
Good morning, Your Honor. Michael Lamb, P79816, appearing on behalf of Ms. Penniman, who is also present via Zoom. Ms. Penniman, will you please state your full name for the record?
Good morning, Shamel Manise Penniman.
We agreed to participate in this hearing via Zoom, Judge Bryant.
All right, today is the date set for sentencing. Based on the time that the matter was set, I did not order a pre-sentence investigation. And so therefore, is there anything on behalf of the people?
Briefly, Your Honor, to provide some context, the complainant in this matter is in a relationship with the defendant's son, and that has led to some conflict over a period of time. On the date in question, February 10th of 2024, there was actually a disagreement between the complainant and her boyfriend, and the mother came to the location and got involved, and it became physical. So despite the amendment to disorderly, we do believe that a term of probation is appropriate. We are asking the court to continue the no contact order, which we believe is in the best interest of both parties. The complainant and the child of the defendant are still in a relationship. So we just ask that both parties keep the peace, and we would leave it to the discretion of the court. But the allegation is fairly serious. The physical fight involves some jumper cables, which were swung in the direction and allegedly hit Ms. Geiger. Now, I'm not sure the extent that the defendant admitted the severity of it, but we are asking the court to impose probation with anger management. And Ms. Geiger, would you like to address the court in any way?
No, not today. Thank you.
Nothing further.
I apologize. I just realized you all couldn't see me. I'm here. I'm not just a voice crying out. All right. Mr. Lamb.
Yes, thank you, Your Honor. So my client did plead no contest under MCL 771.1. So I believe that a probation term is appropriate. I would ask, though, that probation term be no longer than 90 days, as my client is gainfully employed, Your Honor. She has no prior misdemeanor or felony convictions. As Attorney Hill communicated, this was a matter of my client responding to her son, who was in distress, and she was trying to deal with that. My client is deeply remorseful.
Her son was in distress?
Correct. That's why she went over to the location that he was at. I would also note, Your Honor, that this conduct took place some 2 years ago. Since that time, there's been no allegations of inappropriate contact or conduct on behalf of my client. And I would just ask that you take those things into consideration when determining an appropriate sentence for my client.
Does your client wish to make a statement on her own behalf?
Ms. Penniman, this is your opportunity to say anything you would like to the judge. You don't have to, though, if you don't desire to.
Not at this time, Your Honor. Thank you.
Right now, everybody had an opportunity to speak. It's my turn. It's my turn. Okay. I wish my son would call me, talking about he in distress, because him and his girlfriend having a disagreement. You know how to handle a disagreement. You first of all, just leave or walk away or do whatever you're supposed to do. But I'm not gonna come over and get involved in it. I'm not gonna come over and get involved in a disagreement with grown people. Now, if you calling me saying you in fear for your life, which you should have been calling 911, then that's something different. So telling me that her son was in distress, a grown man, and it's my turn. I gave everyone an opportunity to speak. You heard what your lawyer said, and you heard what the prosecutor said, and you had an opportunity to clarify. You chose not to. It's my turn. So telling me her son was in distress and she went over there and got into an argument with her son's girlfriend is silly to me. That's don't make sense to me. And now here we are in court because it didn't make sense. The court is going to impose the following sentence. Oh, Mr. Hill, do you agree that that the recommendation was for the delayed sentence? The people didn't have an objection to the delayed sentence?
Correct, Your Honor.
Court is going to impose a 9-month probationary period wherein there will be an opportunity for early discharge after 4.5 months. So I need a 4.5 month and a 9-month date, please. The conditions of probation are as follows. You shall not violate any criminal law of any governmental unit. You must not leave the state without the permission of this court, and you must make a truthful report to probation on a monthly basis, notifying them immediately of any change of address, phone number, or employment status. You're going to pay the following fines, costs, and fees. The mandatory cost of $210. A $350 fine. Court says restitution at 0. Probation oversight fees for 9 months is $315. If you are discharged early, that amount will be prorated. Of course, there's no pre-sentence investigation fee as one was not ordered. Total fines, costs, and fees, not including any courses for the 9 months, is $875. Additionally, you shall not use or possess any illegal substances. You cannot use or possess any marijuana without a valid medical marijuana card. You cannot use or possess any opiates without a valid prescription and letter of explanation from the doctor. The court is not going to order random urinalysis. However, I do want at least one drug test ordered by probation at some point before the halfway point, which is August the 10th. For the first review. And if we get to the 9 months, the final review is, January 7th. Both of those are at 10 o'clock. You shall not drive without a valid driver's license. You will pay any outstanding tickets that you have with 36th District Court, clear up any warrants that you have. You will attend 6 weeks of anger management and the choices program both through eBay. You will have no contact with the complaining witness. And I believe that completes the court order. Mr. Lamb, you're gonna contact the courtroom either by telephone or, email. Potentially, you could put it in the chat, to make sure that Mr. Flanagan has Ms. Penniman's current address and phone number so that we can mail a copy of the court's order and so that probation can contact her regarding this matter. If you have completed the terms and conditions of your probation by August 10th, then you will be eligible for early discharge. Anything further on behalf of the people?
Nothing further. Thank you, Your Honor.
Anything on behalf of the defense?
Just a point of clarification, Your Honor. You want me to send Ms. Penniman's current address to whom?
Address and phone number to my clerk, Mr. Flanagan.
Okay, will do.
Phone number is 965-2295.
2295. Okay, perfect. Thank you.
We're all set. Everyone have a great day and stay safe.
Thank you, Miss Bryant.
Judge Bryant, it's Judge Bryant.
Judge Bryant, I apologize.
That's all right. Everybody have a great day. Stay safe.
You too.
9 months probation, anger management, no contact. The judge made it clear bad decisions, even in the name of family, still carry consequences. This wasn't about intent, it was about control. So now the real question is, was this a mother protecting her son, or someone who crossed a line she should have known better than to cross? Do you think the judge was right, or did the defendant go too far trying to help? Comment below, hit like, and subscribe for more real courtroom breakdowns.